Voidable judgments, the other kind of motion to vacate. Brought to you by yourlegaligup.com, your advantage if you're being sued by debt collectors. What do you do if a court without jurisdiction over you issues a judgment against you? Do you have a remedy? This video discusses it. It's the other kind of motion to vacate. Usually when people talk about motions to vacate, they're talking about vacating a default that occurred as a result of failure to respond to a properly served lawsuit. There is another kind of motion to vacate, though, for people where the court did not have proper jurisdiction. If you were victimized by sewer service, this may be for you. A quick review. Once a lawsuit is properly served, the court has jurisdiction, that is, the power to address the claims made in the suit, at least provisionally. If a defendant fails to respond appropriately, the plaintiff will get a default order and judgment. That is what happens in most debt cases. An appropriate response that will prevent a default judgment is either an answer or a motion to dismiss the suit, and it is possible to file something called a motion for more definite statement in some states, but that's not very many actually, and usually not a very good way to go. Every allegation in the petition, in any event, must be either moved against or answered. Once that happens, a default judgment should never be issued. If you fail to answer and the court awards a default judgment, you can ask the court to give you another chance by asking it to vacate the default and allow you to defend the case. That's what most people mean by motion to vacate. I discuss this sort of motion elsewhere, and you'll find a link in the article on which this video is based, linked below in the About This Video section, if you want to find the videos that I do about motions to vacate, the other kind. Voidable judgments. But what if the court does not have proper jurisdiction over you? This can happen in two common ways. The debt collector does not manage to serve you properly, or the debt collector sues you in a court that doesn't have power over you because you live somewhere else. Other ways are possible, but these are by far the most common. If you find out that you are being sued in a court that lacks jurisdiction before a judgment, you can move to dismiss the case on that basis. But that can defeat the whole purpose of the rule, obviously, since in order to do so, you would have to appear, specially, it's called special appearance, to contest jurisdiction in the court to do it. And if you're far away, that's impractical. Another way to handle the situation is to let the court rule and then attack the judgment in the correct court. If you know about the situation before judgment, it can present a tough question because either option actually has some costs. But most people do not learn about suits where the courts lack jurisdiction before judgment. They find out about them later. What do you do if that happens? Where the court lacked jurisdiction. When a court enters a ruling without having the actual power to do so, the judgment is said to be voidable. That means that it's possible to have the thing go away as if it never happened. The good news is that there's no time limit on a voidable judgment. The court never had authority to enter the judgment, and all you have to do is to establish that fact. You can do that at any time, and it completely undoes the judgment. The bad news is that you have a high burden of proof to show that the court didn't have authority over you. Most courts require you to present clear and convincing evidence of the facts, proving you weren't subject to the court's jurisdiction. Still, almost everybody I've known who has tried it has succeeded, and that's because of the way these things usually happen. They're usually sewer service, where the process server swears that he served somebody and describes that person. And since they didn't serve you, they don't really have any idea of what you look like, and they don't care that much, and so they describe somebody who may be very obviously not you. That happens probably a lot more often than you might think. You have to prove by good evidence that the court lacked jurisdiction. That's what you have to prove in these things. What you don't have to prove is that you made any mistake. You don't need to allege or prove any defense to the suit, and all you have to do is attack the jurisdiction and the case goes away. Now, it probably does in fact help if you can show that you didn't know the debt in the first place, but that's not necessary. This is an attack on the court's very power to decide the case. What you should not have to prove is that you didn't receive notice of a sewer service filing. Didn't receive notice, that is, actual notice. Suppose, for example, you found it lying in a street nearby, or the summons in the street nearby, or a trash or something like that. That happens actually pretty frequently. Most courts require proper service and not notice of the suit, but I'm afraid you can't count on the courts to apply that rules consistently. You will therefore not want to offer any proof or any indication that you heard about the case in any way prior to judgment. You've got to research your state's rules for voidable judgments and follow the correct rules. They'll be different from the rules that control the other kinds of motions to vacate in most cases, and so you're going to want to know those rules and follow them. Make sure that you know what kind of motion to vacate you're bringing and how to bring the one that you are bringing. You know you can't take what I say here as legal advice. I can't give you that. The rest of the red tape is below in the About This Video section. You can defend yourself without hiring a lawyer, but you don't have to do it alone. We can help. Helping people protect their rights is what we do. Protect what's yours and don't let the debt collectors rip you off. YourLegalLegUp.com